Well, the Supreme Court definitely threw us for a loop. A lot of people, including me, thought we would get an opinion this morning around 10 a.m. No. But then at 2:30, right before carpool, the Supreme Court drops its opinions in both the healthcare CMS and the OSHA private employer vaccine. It's been quite a day. See, I have major FOMO over Rosie right now. So the key questions. Why did the court rule the way they did, and what does it mean? 2, what can employers do now? And 3, what happens with the rule altogether? Well, remember, the Supreme Court's rule wasn't really about the overall legality of that. It was just whether or not to have a stay, whether the rule could go into effect, while the courts, namely the Sixth Circuit, the Court of Appeals, just below the Supreme Court, they decide the legality of this Emergency and Temporary Standard, or ETS, rule for private employers. So the Supreme Court, by issuing the stay, that means the rule can't go into effect. It'll keep going down to the Sixth Circuit, so they'll decide the legality. But if you'll remember, OSHA had agreed initially after the Fifth Circuit had issued the stay, and then there was the lottery. I know it's kind of yo-yo, but OSHA had agreed initially to hold off on enforcement pending litigation. Well, then once the Sixth Circuit lifted the stay, even though it was going to the Supreme Court immediately, OSHA went ahead to start enforcing it. A lot of employer groups had a difficult time with that because those in HR and in-house counsel know it's been a real challenge to roll out from a practical sense. But now the rule will go to the Sixth Circuit to continue to be litigated, but it will not take effect until it's decided. So even if the Sixth Circuit allows it to go forward, says it's legal, then it would go back to the Supreme Court to decide the legality. If I'm OSHA and I'm reading the opinion today, I would not feel very great about my chances, in part because the majority opinion, which is 6 of the 9 justices, said plain out that the challengers to the OSHA's rule are likely to win on the merits. I'm boggling the words a little bit, but they gave indications that this rule is not likely to survive, especially not as an emergency temporary standard. So what are employers to do? Well, there are some employers that rolled out voluntary vaccination policies. I'm not really speaking about them as much. I'm talking about a lot of those private employers, maybe 1 to 500 employees or other amounts, but those that were covered, but honestly went kind of kicking and screaming into enforcing this rule due to practical reasons or whatever. A lot of those employers held off, and many issued their policies on Monday. Started requiring masks this week, have the paid time off for vaccinations, but a lot now that the stay is backed by the Supreme Court, want to roll those back. So the question is, what can employers say? I've linked below a blog I wrote with just sample text to use that you can tell employees, basically we started requiring this because it was the law, now it's not the law, so we're not going to require it anymore. So you can see that sample text below and look at it and talk to your own counsel to see if it's appropriate for your circumstance if you'd like. So that's what employers can possibly do from a practical sense. Then the last is what's going to happen overall with OSHA's rule. So as I said, the Supreme Court certainly gave the signal that this does not have a great chance moving ahead, at least emergency temporary standard. So the question is that became a lot in the Supreme Court's arguments last week, and a little bit in the opinion as well, is could this be changed by industry? The Supreme Court's majority opinion actually gives an indication that targeted regulations by industry could be upheld. Again, OSHA didn't regulate the healthcare mandate that was upheld. That's the CMS through Health and Human Services. So it's not exactly the same decision about legality that this overall private employer rule is. But the Supreme Court did indicate that certain industries, so some that came about in the oral arguments last week were meat packing, for example, or in the opinion today, the Supreme Court mentions like a lab where they work with COVID-19, that would be more reasonable to have requirements like the private employers did. So the question of what are targeted are, so you could see OSHA looking to develop very targeted by industry standards. So if you're in an industry with factories, the meat packing, keep an eye about what OSHA will deliver. I don't think they're expected to do that overnight, but keep an eye. Also, then whether states would enforce it or even Congress. So I've put this chart a few times, but again, OSHA, there's the federal OSHA, but then OSHA allows states to have certified state plans as long as their protections are all as safe as those for OSHA. So there's been a huge battle of some more conservative states that did not want to enforce the OSHA ETS and whether they can do that. Federal OSHA is would of course take the answer, no, you can't, because that's not as safe. But so you saw a lot of conservative states, when it looked like the ETS would go forward, pushing back against it. Well, now that there's a stay in place, what you could see is some of the more liberal-leaning states, like California, some of those West Coast states, whether they could, under their state OSHAs, look to issue guidance that's very similar to the federal OSHA. I really cringe to say that because I know my HR directors have already had a heck of a time trying to look at the practicalities of rolling this out. And so then having a patchwork and different requirements in different states isn't welcome. But from a realistic perspective, you should keep an eye out, especially for some of those, again, more liberal-leaning states in those OSHAs. The other is Congress, which was mentioned in the Supreme Court today. Congress has not spoken. Congress has not spoken. Congress hasn't spoken, meaning it has not issued a vaccine mandate. Whether that would happen now is, I think all consensus believes highly unlikely. I mean, as Congress pointed out, as Supreme Court pointed out, the only congressional action that's been taken is a disapproval of the OSHA vaccine mandate that had no real practical effect. So I don't think you should look to Congress to be quickly passing a standard like the OSHA ETS. That's just my guess. So anyway, overall point is the Supreme Court has now instituted this stay. So you'll see some that say they struck it down. Again, terminology, they've issued the stay. Practical sense, it seems very unlikely that it'll ultimately take effect, at least as written. So look to OSHA to potentially target this, states to potentially certain states to issue similar regulations. And so it's never a dull moment for sure. But then also for employers that have gone through, I'll link that blog below that includes some sample language to notify employees that your enforcement's off if that applies. Thanks.